Hello, my name is Deneen, and I am one of 3 provincial supervisors in the Vancouver Regional Centre for the Legal Aid now. We had a brand change this past year, so we used to be Legal Services, now we're Legal Aid BC. So in my presentation, we're going to go over basically the 3 levels of service that we provide through legal aid. The first is legal information, the second is legal advice, and the third is legal representation. And the goal for legal aid is to provide collaborative services with other organizations to deliver innovative services so that we can have timely and lasting solutions for our clients. The legal information portion of our services is made available to anyone. Information is provided by legal information outreach workers, or LAOWs as we call them. We have websites, publications, community partners, and self-help centers. We also provide legal advice for those who qualify financially. Advice is given through family, immigration, and duty counsel, or criminal duty counsel, including enhanced duty counsel in Victoria, the family law line, and the Parents Legal Center. We also provide legal representation for financially eligible people with serious family, child protection, immigration, appeal, or criminal problems, and we contract out with private lawyers to provide this representation services. We have 26 community partners providing services in 33 communities around the province. When clients contact the community partners, they can get free legal information. They can get assistance with calling legal aid to apply. They can find their nearest legal aid office, get legal help online, and connect with people who can help them with any other issues they may have. The legal advice services we provide, we have a family law line that is staffed by lawyers who have offices around the province. They give legal advice over the telephone for family law and child protection issues. We also have duty counsel that provides in-person legal advice for immigration law if the client is being detained, family and child protection law, and criminal law. We have 10 Parents Legal Centers around the province. These are offices where they deal with child protection issues. That's their main focus. Their job and their goal is to try to have a collaborative, holistic approach to trying to get children returned home and to deal with any kind of child protection issues a client may have. We have, as I said, 10 offices around the province: Campbell River, Duncan, Kamloops, Prince George, Smithers, Hazelton, Surrey, Terrace, Vancouver, Victoria, and Williams Lake. Each office has in charge of their own geographical location, and 8 of the 10 also have other geographical locations that they service. So for example, Campbell River also assists Campbell River, Courtenay, Port Alberni, and Port Hardy. So if any clients have court in those jurisdictions, the Campbell River PLC will assist them. Applying for legal aid. So prior to the pandemic this past year, applications were taken in person or over the telephone. If they were in person, we have 33 offices around the province where clients can actually go in, have an interview with an intake worker in person. All of our locations are on our website, but because of the pandemic, now almost all of our offices are all taking telephone applications only. There are a couple, I think, now that are taking the odd in-person application at the courthouses. Prince George is one of them. I think there might be 1 or 2 others, but I can follow up on that later. But I believe the only one I know for sure right now is Prince George. Duncan was, but then they also closed recently again. Our Nelson and Cranbrook offices are permanently closed. They are currently closed because we don't have a local agent situated in those communities yet. We've been looking for quite some time. So if you know of anybody a lawyer that's looking to perhaps, take over and become one of our local agents in those areas, please let us know. We would appreciate that. If a client wants to call their local office, they can, like I said, we have our addresses and telephone numbers on our website. We also have a provincial call center that's situated in Vancouver. We have a Greater Vancouver 604 number, and we also have a toll-free number that are listed on the screen here. The call center can take calls from anywhere around the province for all areas of law that we cover, and they can, if a client qualifies, give them a lawyer or assistance in their community. Clients applying for immigration matters can call legal aid on a specific immigration line that we have. Again, we have a Greater Vancouver number and a toll-free number for our immigration clients. We also have a designated line for clients who are in custody. And we have that line because clients who are in custody have limited time to be on the phone. So they need to be on and off the phone as quickly as possible. So when that number pops up on the call center screen, the intake staff know that they're in custody and they can deal with those clients first. What legal problems are eligible for coverage? So clients applying for legal aid must qualify both financially, and their legal issue must be something that we cover. So they have to qualify both ways. For coverage for criminal, we provide standard contracts, which are our full contracts, where charges are serious and there's a likelihood of jail, or it falls within one of our exceptions. And I'll go over those briefly in a minute. We also have criminal early resolution contracts, or CERCs as we call them. These are contracts where the client is either facing, they're not facing the likelihood of jail, or their financial income is over our standard financial guidelines, but within $1,000 of that. So they can be up to $1,000 over our regular guidelines, or both. They could have an issue that there is no likelihood of jail and they're over our guidelines. And so one of those three scenarios, they can actually get a CERC as long as there is no trial set or and there's no preliminary hearing set. In the past, if these clients didn't have a likelihood of jail or they were over our financial guidelines, they would have been refused. We've had CERCs now for, I think it's coming on just 2 years, so they've been around for a little bit. And our exceptions to the likelihood of jail rule are if a client is a youth, they get legal aid in almost automatically. There's a couple areas where they may not qualify, but youth clients get legal aid. It doesn't matter if there's likelihood of jail or what their family's income is. If a client has mental health issues or a physical disability that would affect their ability to self-represent, we can provide coverage under a standard contract. If there's a loss of livelihood concern, so if a client is a taxi driver or a bus driver or something like that, and they have an impaired charge and they could lose their license, then we could look at covering that. And we also have, if a client self-identifies as Aboriginal and they've been charged with a hunting or fishing offense, normally that offense, they would get a fine, not jail time. But if they do self-identify as Aboriginal, we can take a look at perhaps covering that as well. And there's also times when it could affect their immigration status, a charge, so we can look at that as well. So those are our exceptions to our regular likelihood of jail rule. We do have a package that we're going to be either we'll put up on our website at some point, or we might be emailing it as well. But it is basically an overview of our coverage guidelines that will set out. It's more detailed, showing you what we cover for all of our areas of law. So that'll probably answer some of your questions if you have any today. For family law, if the client has serious family situations, which would fall within our standard coverage, like our criminal, these issues usually include parenting issues with respect to guardianship, parenting arrangements or custody and access, protection orders, child support, and more, depending on their situation. And the issues need to be addressed immediately to ensure the safety of the children and or the client, as well as the parent-child bond, if it could affect that negatively. There are exceptions to these guidelines as well, just like the criminal guidelines. And we address those under what we call an exception review. So those would actually come to the 3 provincial supervisors, myself and my 2 coworkers, and we review files that wouldn't normally fall within a standard contract. That's one of the things that we do as a provincial supervisor. We do file reviews on specific types of cases where it doesn't fit within our standard guidelines, whether it's financial or coverage. We also, which I did forget to mention at the beginning, we also train, support, supervise, and just assist with all our local agent offices around the province and the local agent assistants. And we also review files for all of our intake workers, including the staff in Vancouver and Terrace, as well as the local agent assistants. And we also, if a client is refused legal aid and they want a review of that decision, that is something that we look at as well. Now, similar to the criminal files, if there is we have the CERC. So for family, we have a different type of contract called the limited representation contract. And that, if they don't fit within our standard guidelines with our with the different issues that we cover, and that they're not as serious, we have these different types of contracts. And they're there to provide support for issues that we don't consider as serious or urgent as our standard coverage guidelines. Like criminal, clients approved for this service would have been refused in the past. And basically with limited representation contracts, it is things that, if they just have a child support issue or they want to change an access arrangement or something like that, it's not urgent. There's no safety concerns for the parent or anything or the children. Then, it's just basically a little bit of representation to help them get started, get prepped for court, that kind of thing. It is very limited. We've had these around for about 3.5 years now, I believe. And on September 25th of 2020, we amended them to include more services that we can cover. And we also included the financial guidelines to increase them for these types of cases. However, because we expected there to be, and there has been, more people applying for these, we did have a limited budget. So we also then had to reduce the amount of hours that the lawyers could work on it to fit within our budget. These contracts are only good until March 26th of this year, because that's the end of our fiscal year and we don't know what's going to happen beyond that. Once we know, we'll be able to see if the contracts are going to continue, if they're going to change, or if they're going to just eliminate them. We don't know. So at this point, if clients apply, services are only good to March 26th. Basically, they get 11 hours, 8 hours for the lawyer to do general prep, and 3 hours for the lawyer to appear in a provincial or Supreme Court case conference or at uncontested, short hearings. They can't appear in anything that's contested or a trial. It's just basically to get the clients going or help them with simple issues. We don't cover divorces in either a standard or a provincial or the limited rep. For our standard contracts, we don't cover property division either, but in a limited rep, if the client does have property division issues, we can take a look at them just to get them started and help them with any legal advice or assistance they may need. And with our exceptions for our standard contract, similar to the criminal, if a client has mental health or physical disabilities where there's a barrier and they can't self-represent, it might be an issue like child support that we don't really cover on its own normally if the client doesn't have barriers, because it's not urgent. But if they do have barriers, we can look at giving them assistance. And if we approve it, they'll get a full contract. There are other exception review categories we go into look at, but I won't go into them all here. But the barriers to self-representation is the one we use the most. Child protection and removal under the CFCSA, which is the Child Family Community Services Act. These are where the Ministry of Children and Family Development, or MCFD, or a designated agency has removed a child, or where there's a risk of the child being removed. This could also include custody and or access issues arising from a child that's already in care. So in these cases, in almost all cases for child protection issues, we cover them. There's the occasional exception to that where we don't, but if there's a risk of removal or they've been removed or the ministry is involved, we want to make sure that the client has some kind of legal representation to assist them. The PLCs, the Parents Legal Centers that I talked about earlier, help clients in the communities that they cover, and they basically do the same thing as one of our private lawyers would do. They try to, get the children returned home or keep them from being removed at all. And if they have to go further and it has to go to trial, then the Parents Legal Centers actually don't take the cases to trial. At that point, a private lawyer would be referred to, the client would be referred to a private lawyer to proceed to the trial. If there is no Parents Legal Center in the community, or they have a conflict or anything like that, then intake will appoint private counsel to a client if the Parents Legal Center can't take them. These cases, there's, like I said, we cover most of them. This is the only type of case where we actually will give a lawyer to a client if the child hasn't been born yet. So if the ministry is involved with a mother who's pregnant and they're involved, they're asking questions, they're considering removing when the child's born, we can definitely give the client a lawyer before any of that happens to try to keep the child from being removed at all. So for family, we don't do that. There has to be a child born before we can give assistance under a family case. We also provide lawyers on occasion to what we call third-party applicants who want to become a party to the proceeding. So parents are automatically considered a party to the proceeding because they're the parents of the child. But in some cases, other people want to be included as well. They want to have a say or a voice about what happens to the child. It could be a grandparent, it could be a sibling, an aunt and uncle, but they're not a party to the proceeding in the court matter. So they're not listed on the court documents or anything, but they want to be, and they want the child to come and live with them. So in that case, they can make an application for legal aid, and we send it up to our family law team, who will review it and determine if we feel the client has a good chance of success. If they approve it, then we would give the file to a lawyer who would then make an application to the court to try to have the client become a party to the proceeding. If it's successful, then they continue on just like they would with any other CFCSA file. And if it's unsuccessful, then that's the end of the case. There are some times where we do get clients that come in and for issues that we don't cover because it is something that the ministry can actually provide them with a lawyer. Sometimes children over the age of 12 can be, the ministry wants them to review a custody arrangement they're going to do, or they have a plan of care for the child and they want them to have a say. That's not something that we provide counsel for. That's something that the ministry provides them with a lawyer. So they have to speak with their social worker. Also, if a client comes in and talks to us and they are a third party that the ministry is placing the children with, and it's the ministry's idea, it's with their consent and they want to place the child with this person and they want the client to get some legal advice. Again, that's something the ministry provides them with. We don't provide them with that. It's only if they're wanting to have the child come and live with them and the ministry isn't consenting that we'll look at that. Reciprocals. So what reciprocals are applications with other provinces for family or child protection issues. In the past, up to about 3.5 years ago, if a client had a legal issue in another province, they applied in BC. We determined if their issue was something we covered here and if they were financially eligible. If they were, we would send it off to the other province and their reciprocal coordinator would review it, determine if it was a legal issue they would cover. They didn't worry about the financials because, they took our word for it that the client was financially eligible in BC. And then if it was something they could assist with, they would find a lawyer for them in that province. But they did decide to change it. So now clients if they have a legal issue in another province, say like in Alberta, they just contact Alberta Legal Aid directly and make an application with them. They don't go through us anymore, which is similar to what we do with criminal files. If a client has a criminal matter in another province, they have to apply there. There are times when it's difficult for a client to maybe get in touch with the other province. They may not have a computer or their phones. They can't make calls to another province. Most of them have toll-free numbers, but not all. Or they have online applications. But if they have issues, then they can actually contact their local office or their call center, and we can take what's called a courtesy application, and then we forward that to our reciprocal coordinator, who forwards it to the other provinces' reciprocal coordinator for them to process the application for the client. So we don't want to think that the client can't get help just because they can't access the online or telephone services. The only province in the country that does not have any type of access if you're out of the province, which is a toll-free number or online applications, is Quebec. So for sure, if you have a client that has issues in Quebec, they'll need to do a courtesy reciprocal application with us for sure. Immigration. So what we deal with in immigration is when clients want to make a claim for refugee status, or the client faces an immigration proceeding that may result in the removal from Canada. Those are the two main things that we look at. We do look at some others in small amounts. We don't deal with sponsorship issues or sponsorship breakdowns or anything like that. Most of our stuff is related to, serious claims of safety for a client, or if there's a risk of them being deported. There is more detail in that handout that I talked about earlier, the coverage guidelines, a little bit more about what we cover for immigration. We also have, as I mentioned earlier, we have a direct immigration line. I put it up here again, where if a client wants to apply, they can call the Vancouver number or a toll-free number. All applications for immigration cases have to be done through Vancouver. No other office can take an application. So if you have a client that lives in Kamloops or Prince George and they have an immigration issue, they have to call our call center to apply. Clients that live in the Lower Mainland before COVID could go and make in-person applications in our Vancouver office. But at this point, we're not taking any walk-ins, so everything is over the phone right now. So that's our coverage guidelines in a nutshell, pretty quick. But these are our financial guidelines. So we have two types of income guidelines. We have representation eligibility numbers, and we also have advice guidelines. So this set here are representation income chart. So the income is monthly net income. It is after taxes and after certain deductions that we deem that we will take off. And I'll go over some of those in a minute. So we have our household size, and then we have our standard cases. This is our guidelines for the amount that they can make. And we also have our child protection, CFCSA, our CERCs, and our family or limited representation contracts. So those all can be $1,000 over our standard guidelines. Our CFCSA clients are always $1,000. They can always make up to that $2,660 for a single person, no matter what their case is. For CERCs and for criminal and family, it has to be a CERC or a limited rep for them to have that guideline cut off. It does change usually every April when our new fiscal year starts. So these guidelines are effective as of April 1st, 2020. So they'll most likely go up again April 1st, 2021. These are our personal property exemption guidelines. So a client can have a little bit of money in the bank or liquid assets, but if it's over a certain amount, they may not qualify for legal aid. So this is for say a household size of one. A person can have up to $2,000, say in an RSP or a bank account. If it's more than that, they may not qualify. So that's for most of our assets. We have a couple that are separate from that. So family vehicles, if they're allowed up to $15,000 in equity, so it doesn't fall within this exemption box. So if they own a car that's worth $25,000 and they owe 10, it's worth the equity is 15, then the car would automatically in the system be overridden. If they have a family home, if it's part of their family case that they lived in it with the opposing party, it can be overridden as well, no matter what the equity is, because it most likely will become part of their case and the client doesn't have the ability to sell the home or take loans out on it when it's still, it could be a property and an asset that's in dispute. That also goes for things like RSPs and that kind of thing too. If they become part of the family case, then we may look at overriding them. If it's not, the house is not part of the family case, perhaps the client owns it separate from the opposing party, or if it's a criminal case or child protection or immigration, something like that, and they own a property, then we have exemption guidelines as well. If the equity in the home is under $100,000, we can override it, although we'll need proof of that. We'll need their property assessment and mortgage papers. If it's over $100,000, then what we would need is for them to go to a bank and get a letter to say that the bank will not provide them with a second mortgage or a line of credit or a loan or anything towards their property, so that they can't do that and use it for legal fees. And as I mentioned, we also have financial guidelines for advice services. So this is for duty counsel, mainly family. So this is our duty counsel in the courthouses where clients, in the past we're seeing in person. I believe they're dealing with them on the phone as well. And this is also for our family law line. So these numbers, again, it's net monthly income. We don't ask for income verification when we talk to them. We just ask them what their income is, and we don't look at their assets. We just need to know what their income is to see if they can get the advice services. So as I mentioned before we get into the financial discretionary coverage section here, there are some deductions that we will take off income. So if a client is paying for child support or spousal support, whether it's court ordered or not, we can deduct that from their income. If they're paying for daycare expenses, if they're paying for medical expenses, whether that's extended health. In the past, when people were paying MSP, we would deduct that if they were paying it out of pocket. Dental, massage therapy, chiropractor, all that kind of stuff. If it's stuff that they pay for on a regular basis, prescriptions, if a client is diabetic and they're paying so much a month on a regular basis as opposed to just a prescription here or there. If the client is paying for special tuition or tutoring and that kind of thing for a child that is special needs, if they need to pay for a supervised access, so they have to pay for the supervisor, we can look at that as a deduction. If they have to spend any monies to access their children, if their children live quite far away and they need, they're going to see them once or twice a month, they're paying for hotels and gas and ferries and different things, we can look at deducting that. And also if they're paying for monies to overseas for a spouse or children, or if they've declared bankruptcy and they're paying bankruptcy fees, or if they have any court fines. And again, all of these things that we deduct have to be something that they pay on a regular basis. It can't be just something that they pay once in a while. And we would need documentation for that as well. It also, and we look at that, we look at the assets and we look at the income, and that's what we come to determine if a client's financially eligible. That is like a simplification of what we look at. So we always recommend that clients come in and apply anyway, even if they look on our website and think, maybe I don't qualify. The intake worker is the one that knows best whether or not someone will qualify. So if you have a client, still get them to come in, make the application, because there may be something there that we can look at and the client may actually qualify. If they don't qualify, then they do have a right to review, and they can't have it reviewed unless we have an application in the system. And if their situation changes, then we have a lot of information already on the file. So it's always helpful to get them in to apply, and just don't assume that they wouldn't. Okay. So like our other reviews, like we had our exception review where if a client's issue was something that didn't fall exactly within our coverage guidelines, we also have a review for clients that are slightly over on income and assets. So it's called the discretionary coverage review. So it's based on our discretion on whether or not how serious their case is and how much over they are in our guidelines. So the general rule is if they're with between $100 and $200 over for criminal cases, and that is for clients who have a trial or pretrial set, because if they don't, then they would get a CERC. But if they have a trial or pretrial and they need to get legal aid and they're over by $100 or $200, sometimes a little bit smidge more depending on their case, but we'll take a look at it. And if we determine that, you know, that it's serious enough, then we'll give them a standard contract. They won't get a CERC. For family, if the client's issues are coverable under standard guidelines, and they're $100 or $200 over, we can look at perhaps giving them a lawyer under a standard contract. We do have the limited representation contracts that do allow us to provide them with lawyers if they're up to $1,000 over, even if their issue is covered under a standard. But if they're over financially, we don't always cover them. But if they're still within that $100 or $200 little gap at the beginning, we try to look at that as a standard. And if we can approve it, we would prefer to do it as a standard because they will get more services. So, but if they are over by $200 up to the extra $1,000, then they would get a limited representation contract. Okay. If they're over, again, by the $100 or $200 for immigration or one of our appeal cases, then again, we can also look at those as well. Our appeal cases are cases that are not appealing our decision, but appealing a court decision. So we have a department that deals with that. So if a client wants to appeal, like, for example, a family court order, or on a criminal case, if they want to appeal a conviction or a sentence, our appeals department looks at that. They can also be over on assets and it may not qualify, but if they're over on assets by $500, it's not a lot, but up to $500 for all areas of law, including child protection, CFCSA cases. And if the case is serious and complex and we have the budget, a lot of our issues are based on our budget. All the exception things that we have, exception reviews, discretionary reviews, that kind of thing, they're based on whether or not we have the budget. If our budget gets cut, then those are the first things that go, unfortunately. There is no income discretionary coverage review on child protection cases because they already get the extra $1,000. So we don't have a discretionary review for those, but we do have the $500 for assets if they're over. So requesting a review of a denial of legal aid. So if a client is denied, they can ask for a review of that decision. It has to be in writing. The client should state why they disagree with the denial and explain why they believe they should get legal aid. And the client should include any supporting documents they have. Coverage and financial eligibility reviews are what they're called, and they must be submitted within 30 days of the denial to legal aid, denial of legal aid to the provincial supervisors, which is myself, my two coworkers at the Vancouver Regional Center. Our address is included here, our phone number, our address, our fax number, and our email address. This whole presentation will be up on our website as well. So if you don't get a chance to write all this information down, it'll be there later. Working together. So hopefully this presentation was beneficial and will assist you in helping your clients apply for legal aid, help them understand the intake process, prepare for the interview. So the more documentation they have, the more information they have for us, it's very helpful. If they have any questions, to have them written down and prepared so that they're not trying to scramble to remember what they wanted to ask us. And if their documentation is organized, so they can get it to us, and if there's something that we need, we will ask the client for it. We don't expect them to have it all prepared because they don't know what we're going to need before the interview. We will let them know, and we usually give them a letter, either mailing it or emailing it. And it's got a list of things that we require, and we tick off the ones that are relevant. We also want to make sure that clients follow up on the status of their file and provide intake staff with requested information. It does happen quite often that clients will apply and we don't hear from them again from 6 months, and they call back and they want to know why they don't have a lawyer, but they never provided us with the information we asked for. And until we have whatever we've asked for, we can't finish processing your application. So it's important that they get it to us as quickly as they can. So the other thing to remember too is when we interview clients, we may ask some kind of invasive questions, especially on family cases. If there's abuse allegations, that kind of thing, we need to know. If clients are talking about issues that are sensitive, it's preferable if they don't have their children around. It's not always possible, but it does happen. If you're with a client during the interview, please allow the client to answer the questions from the intake worker. It gives the intake worker a better idea of the client's situation, and we can determine based on what, how they're talking and what they're telling us about how much they can handle, and whether or not we may need to do an exception. And maybe if they have some barriers to self-representation, but we need to be able to talk to the client to find that out. Also, if you are interviewing with a client, you come to the interviewer, you're with them over the phone, the client has to give us consent, either verbally or in writing, to speak with you beyond that interview. So if the client's talking to us about stuff and you want to call us the next day to find out the status or give us more information, if we don't have that consent on file, then we can't talk to you, even if you were in the interview. So it's important that if the client wants us to speak with you, that they tell us, well, we will ask them anyway, but that they have to let us know that they want you to call on their behalf, or it has to be in writing. So just make sure that you're aware, because we unfortunately, everything is confidential and we cannot give out information to anyone unless we have the client's consent. Okay. So as I said at the beginning, my name is Deneen. I'm one of the 3 provincial supervisors in Vancouver. This is my phone number, my fax number, and my email address. If you have any questions or concerns, or you ever want to talk about a file that you may have had a problem with, or a client has some issues that weren't dealt with the way you thought maybe they should have been, you can contact us and we can discuss it with you, as long as we have the client's consent. Or if you want to talk to something just about a case, just in general terms and not with clients' names or anything like that, we can assist. Okay, thank you very much.